don't think that we're not paying attention to you. Okay, welcome to the last case of the morning docket. Today, I'm Chief Judge Karen Arnoldberger. I'll be presiding over the panel today, which simply means I attempt to keep time. Joining me today on this panel, I'm honored to have on my right Judge Henry Green, who hails from Leavenworth, Kansas. He's the longest serving member of our court, having served on the Court of Appeals for 28 years. To my left is a less senior judge than that, but not by much. Judge Boozer, Michael B. Boozer, has from Johnson County, has been on our court for 16 years. So you have a lot of experience here on the panel looking at your case today. I'll call the case in a minute, but because we are on YouTube and people may be watching this case and not having any background at all, I will give you, well, since there's an appeal and a cross appeal, I'll each give you a minute or so just to explain, a minute or two just to overall explain the facts of the case and to give context. And then after that, I'll start your time. We discussed how we were going to do this before you came on, and because there is a cross appeal, you'll each have 15 minutes to argue. So make your best arguments on both your main case and your cross appeal or appellant stance. But I will give each of you a chance to carve out rebuttal time from that 15 minutes. So, so we would start with the appellant, the appellee, and then the appellant's rebuttal time, and then the appellee's rebuttal time, if that makes sense, okay? But you still only get 15 minutes. So with that, I'm going to call the case of 123297, James Morris, appellant cross appellee versus Shilling Construction Company and Midwest Builders Casualty Mutual. If you would state your appearances, please.
May it please the court, Mitch Rice appears on behalf of the claimant appellant, Mr. Morris.
May it please the court, Jackson Wagner for the appellee and cross appellant, Midwest Builders and Shilling Construction. And Your Honor, before we do get started, I do have a question about the cross appeal. As the cross appellee did not file a brief on the cross appeal under Supreme Court Rule 7.02, are they still allowed to have oral arguments on the cross appeal?
I hadn't considered that at all. I think we're going to go ahead and allow oral argument today, and we'll take that into consideration, I guess, when we figure all this out. Okay, so you're saying that the cross appellant didn't file a brief, or the cross
appellee. So we are the appellee cross appellant. The cross appellee, which would be
okay, so Mr. Rice,
correct,
did not file a cross appellee brief.
Correct.
Yeah, we'll still allow argument, but no, if there's no brief there's nothing for us to. I mean, you can't be citing new cases and stuff in your oral argument. But okay, we'll sort that all out when this is over, right?
Thank you.
I hate to not give him a right to argue that and then wish I had later. So I think we can figure it out. Okay, so we'll go first, Mr. Rice. You may proceed. Oh, did you wish to reserve time for rebuttal, Mr. Rice?
I do, Judge, and I think we'll be completely fine on time, but if I could reserve 3 minutes.
3 minutes. Okay, got it. You may proceed.
Very good. By way of background, just very briefly, Mr. Morris was employed as a laborer with Shilling Construction. He was doing some asphalt work, working with a big asphalt buggy. He was in contact with the buggy. The buggy came in contact with a dump truck that was in contact with some power lines, and they say 69,000 volts went through Mr. Morris's palm of his hand that was grabbing onto the buggy, and then exited both of his feet. That's the start of the case. He suffered injuries to his back, right leg, and right hand. and pursued a workers' compensation case. The real issue here is nature and extent of impairment. What was the percentage of impairment? And Chief Judge, I note that you were on a case that's been brought up, the Zimmerman. And when I read that, I thought, oh boy, I have my work cut out for me. But I'm glad that we can have some oral argument, because I think the issue may be a little bit different. I at least wanted a chance to explain really what we're asking for. The ratings in the case, 12, 8, 5, and 9. The 8 and the 5 were under the 6th edition. The 12 and 9 were under the 4th. And Chief Judge, I'm sure you're familiar with Johnson and all of the history there. And I don't even think I want to get into all of that unless the court wants to hear me drone on and on about it. But it becomes really important to my client whether or not he breaches that 7.5% threshold. And that's the big issue here. Most would think, well, who cares if it's a 6.5 or an 8? That's not that much money. Well, it makes a big difference in the amount of money. My argument all along has been, and even when Johnson, decided by your court, was pending with the Supreme Court, was that the judges and doctors are all under the assumption that they have no leeway. They have no opportunity to deviate at all from the 6th edition, and that the 6th edition is controlling. And the Supreme Court said otherwise and said, no, it's a starting point, and you're allowed to consider competent medical evidence. And so when I read Zimmerman, I was surprised to see the court.
Go ahead.
When the court said the 4th edition is not relevant. And I think that's true, but I think maybe the court misunderstood the argument in Zimmerman, or maybe I would put it this way: my argument's a little bit different than Zimmerman was making. And if I refer to that case, because I think it's really important, the Zimmerman argument was that the ALJ and board incorrectly interpreted the statute that mandated the use of the 6th edition, asking the court to reverse and remand with instructions for the board to determine her impairment by considering whether a 4th edition impairment rating constitutes competent medical evidence. Kind of what I'm asking the court to remand this back to the board or the ALJ, probably the ALJ, because the ALJ in this particular case went out of his way to say, I am bound by the 6th edition. The 6th edition is controlling, didn't even consider any of the other evidence. I'm not saying it either is 4th or 6th. I'm saying consider all of it. And it's somewhere in between. It could be the 1st edition that I bring into evidence. It could be some opinion from a doctor that he made up his own rating system.
Right.
But I'm not saying it's either 4th or 6th. Judge didn't consider my 4th. It's just that has to be some competent medical evidence. It's been competent medical evidence for 20 years.
Excuse me, didn't your doctor, was it Dr. Murata? Is that?
Murata. Yes, Judge.
Okay. Well, didn't he give a rating based on using the 4th and 6th?
He did, Judge. He gave
okay, and you're saying some doctors are so confused that they think they have to follow the 6th, yes. But he did do both for us.
He did do both. We've been asking the judges or the doctors to do both, with the idea that the judge would then take all of that into consideration to say, okay, I know I'm supposed to start with the 6th edition pursuant to statute, but I can also take into consideration all of this other evidence, so long as it's competent medical evidence. And
your case, Mr. Rice, I mean, the issue here is all this briefing, all of this kind of occurred while Johnson was involving, and then Zimmerman was just published a couple of weeks ago.
Yes.
So it seems like a lot of cases were looking at both the 4th and the 6th because they weren't sure how the Supreme Court was going to come down.
Sure.
And Zimmerman basically said, you don't start with instead of comparing what the fourth and the sixth said, the fourth is irrelevant. You start with the sixth, but whatever you decide has to be supported by competent medical evidence. And I think in Zemero, they actually gave more than the sixth recommended.
They did. You're right.
Okay, go ahead.
And I guess that's still my argument is a little bit different than what Zemero.
Okay, yeah, I see what you're saying. You're saying that the fourth is some, I mean,
it's just evidence. And I feel
evidence
like
of competent medical evidence of what would be appropriate.
And I feel like the minute I say fourth, everybody wants to close their ears and say we're not under that edition anymore. But it's at least medical evidence. And you're right, the posture of this case was kind of a mess in that we were waiting and waiting. But I will also.
So excuse me, under Johnson, you want to basically says what Johnson said. You could this is a starting point. Okay, it doesn't eliminate this the fourth.
Sure, and that's what I want. All of the judges up until Johnson, I guess. First of all, everyone was under the assumption that the sixth would be thrown out as unconstitutional, as your court decided, but it wasn't. But from that point on, I think what we're finding is all of the judges had been misapplying the statute and misinterpreting the law, and under the mistaken assumption that I've got to follow this sixth edition. Any other deviation from that, I'm not allowed. I'm not allowed as a judge to take into consideration any other competent medical evidence. It's sixth edition only. And I would also point to, I just got a decision from a Wichita ALJ just a couple of weeks ago. I mean, talk about a mess. He is still saying, he says the primary holding in the Johnson case applies here as well. And he decided just the sixth only. And he said the phrase based on indicates the legislature intended to use the sixth to serve as a starting point for the more important and decisive competent medical evidence. That is the application of a standard while setting the legal parameters of any possible final resolution leaves work to be done. And he's quoting Johnson. And so then he goes on to say it's unclear to the court what form possible other work to be done might be in when the sixth edition ratings is statutory answer. So he's basically saying, hey, I'm controlled by statute here. And then he goes on to, in my opinion, I think he's criticizing the Johnson court, saying the Johnson court's comparison of the guides to permanent impairment to the criminal sentencing guidelines reveals a surprising misunderstanding of the guides to medical impairment and how the Workers' Compensation Act. Criminal sentencing guidelines allow for departures. The Kansas workers' compensation system has no similar mechanism for the court to adjust a finding under the guides to permanent impairment.
Okay, and that's an ALJ that decided that, or a district judge?
Just a few weeks ago, ALJ.
Okay, so explain this to me, Mr. Rice. Let's assume the sixth edition never appeared on the scene.
Correct.
And we're back to the fourth edition. So didn't doctors look at what the fourth edition said and then made a decision to stick with that, to go above it, below it, based on their medical expertise, correct?
Yes, all the time.
Okay, so don't we just at this point now substitute the sixth?
Yes.
And it's the same thing. They look at the sixth as a starting point. The doctor can go above it or below it based on competent medical evidence.
Yes. And to that, I would say, I think the courts, when I say courts, the ALJs had misinterpreted when that statute was amended. You can read it.
You can read it as saying you must only.
Yes, because that part where it talks about competent medical evidence is up above when it talks about fourth.
Right.
Down below, they had the sixth, and they don't mention competent medical evidence.
Right.
And so I think
that was the whole point in Johnson.
That is. And then Johnson just says, well, it's constitutional. They can start with the sixth, but then do whatever they want from there. And I agree with that. But the ALJs have been under the mistaken impression that they couldn't do that. And so if you remand this back to the ALJ and say, hey, consider all competent medical evidence, don't even mention the fourth, and he looks at it all and says, well, guess what? My rating remains the same, then fine, I can live with that. But they've been hamstrung by the misapplication of the law. So that is my argument. I'll leave it at that.
Okay. All right. Any other questions of Mr. Rice? Okay. Did you have anything else you wanted to say in your first 12 minutes?
There's an issue on the cross appeal. Those are such minor issues. It's average weekly wage. We argued about that by a few dollars. I won that issue. And then the second is was arguing about whether his wrist was impaired. Those are such minor issues. And I think the board is supported by competent medical evidence in the board decision. So that I didn't really see that as my main issue is the rating. So,
but don't we have a little minor issue with that? I agree with average weekly wage. The board excluded, if I understand, part-time. Okay. And I think your opponent is saying that even part-time should be included in determining those average weekly wage for the 26 weeks before
yes.
He was electrocuted. Is that right?
Yeah. And yes, Judge. And my argument on that is the statute says weeks actually worked. If you work one day in the week, you didn't work that week. I mean, that's the argument. So
okay.
Any other questions? Okay, Mr. Wagner. And how much time did you wish to reserve?
I would reserve 3 minutes for rebuttal, Your Honor.
Okay, go ahead.
Thank you, Your Honor. May it please the court, Mr. Jackson Wagner for the appellant for the appellee and cross appellant, excuse me. As Mr. Rice said, there are three main issues here. The first of which being whether the fourth edition remains a viable following the Supreme Court's opinion in Johnson and this court's opinion in Zimmerau. The second being whether the Workers' Compensation Appeals Board followed its own factual findings in issuing an impairment rating supported by competent medical evidence. And the third being the claimant's average weekly wage being determined by KSA 44-511 after the 2011 amendments took place. So beginning with the appeal by Mr. Rice, I would argue that this issue is entirely resolved by Johnson and by Zimmerau. That Johnson, as Mr. Rice said holds that the sixth edition is a starting point and we can use competent medical evidence to either go above or below our sixth edition rating. Now, the question is the fourth edition competent medical evidence? And the legislature, when they amended the statute and said that for all injuries after January 1, 2015, we no longer consider the fourth edition, we use the sixth edition, answered that. And the court only reaffirmed that answer in Zimmerau and said that no, the fourth edition is irrelevant. We can no longer consider it in issuing any impairment ratings. And so what we are left with is the sixth edition, and then you adjust based upon competent medical evidence one way or another. I understand that Mr. Rice said, I could present the first edition, third edition, fifth edition. Well, I brought that point up in my brief that at no point has anyone argued that they should consider the first, the third, or the fifth edition, because clearly the legislature said it was either the fourth or the sixth, and that's what we had to start our analysis with. And so now we're considering what is competent medical evidence. And because it's not the fourth edition, the Court of Appeals, and this was later quoted by a board opinion in Clayton v. University of Kansas Hospital. This is the Court of Appeals opinion 53 Can App 2D 376. That is competent medical evidence in the context of workers' compensation is an opinion asserted by a healthcare provider expressed in terms of a reasonable degree of medical probability or similar language. And so it's a doctor's opinion based upon all the evidence that they considered. In this case, we have two doctors' opinions. We have Dr. Marati, which was hired by the claimant, and we have Dr. Hufford, who was appointed by the judge as a neutral independent medical examiner. Both doctors examined the claimant, looked at all the medical evidence that was submitted to them. They talked with the claimant and they were deposed, meaning that they issued a report and then backed up those opinions in their report. So we have competent medical evidence to base the decisions on. Both doctors, when looking at the impairment, didn't just go with, this is the medium value that the guides gave. They both deviated one way or another, not completely outside the mandates of the guides, but within the mandates of the guides. And there's nothing that says that you have to give an impairment rating that goes outside the guides. You just can if you choose to. And so what we're left with is Dr. Hufford's 5% rating and Dr. Marati's original 8% rating, both based upon the 6th edition and competent medical evidence. This is where we segue into the cross appeal issue, unless the court has any questions for me specifically about the appellant's issue.
You
Okay.
know, looks like you can go on.
Thank you. In the first issue of the cross appeal, it's entirely based around whether the board followed their own factual findings. So the board issued a decision. They said that we understand that the claimant had an injury by electric shock that resulted in an injury and permanent impairment to his back and to his right leg, but not to his right wrist. Although the entry wound was in the right hand, they threw out the administrative law judge's justification that an entry wound in the right hand means there's impairment in the right wrist. As the claimant testified, the wound healed up and he didn't have any issues with his hand. And so after making that decision, the board then goes on to state, and I will quote, "It's unrealistic to conclude the main source of claimant's impairment or 1/2 of Dr. Marati's rating derives from the claimant's right wrist. Due to these concerns, the board discounts Dr. Marati's rating by 1/2. So we start with the 8% rating issued by Dr. Marati. The board says there is no wrist impairment included. We're going to discount by 1/2, meaning it's a 4% rating. And then they also say we're going to average the two remaining ratings. We have a 5% and a 4%, so we should end up at 4.5, rather than the 6.5 that the board gave, if they're following the strict rules and the logic that they laid out in their order. And Administrative Law Judge or Board Member Belden pointed all this out in his dissent. He said that, I agree with the board. We're going to discount Dr. Marati's rating by 1/2, but I think we should follow Dr. Hufford's 5% rating instead of averaging Marati's and Hufford's ratings. And so I would ask the court to merely correct the issue in the board's ultimate conclusion. Because
excuse me, where does the 6.5% come into play?
So the 6.5 was the ultimate rating that was found by both the administrative law judge and affirmed by the board. Although the board said that we were left with essentially a 4 and a 5, they held that the ultimate impairment was 6.5%, but they didn't really provide a rationale for why we're left with 6.5%. When everything in their order would lead you to conclude they intended to have a 4.5%, or at most 5% as opined by Dr. Hufford.
Why couldn't we go with the 6.5 and just reduced it from, look like the board overlooked, it overlooked, the LLJ talked about the right wrist impairment and implied a part of the 6.5 in that. But why can't we just look at the board basically took the LLJ 6.5? Why can't we just reduce it by just reducing the risk impairment in the LLJ's determination for 6.5?
Sure. And so I think what I'm understanding your question to be is we have the 6.5 and the of that, roughly 4% was for the wrist as opined by Dr. Marati. Okay.
Correct.
And so are you asking why can't we just reduce that by the wrist rating to get down to a 2.5?
Well, not 2.5, but what you had the ALJ average to get to the 6.5. if you just take away the 4 and then average from there on, you get pretty close. I think you get about 5 or something of this nature.
Correct. You would have the, if you take away the 4% from Dr. Marati's 8%, you have a 4%. Then you have the 5% by Dr. Hufford. So sure, you would end up somewhere between 4 and 5.
Okay.
And that's what the dissent said, was I would just adopt the 5% as opined by Dr. Hufford. And I don't think either, I certainly didn't appeal the factual issue of whether there was an injury to the wrist. I haven't seen anything from cross appellee that has appealed that issue. So I think the actual issue is just the ultimate impairment opinion. Now, the other way, and I think the only way you can justify the 6.5% is that the board deviated from the ratings given. I think that's the only possible way you can justify them getting to 6.5%. And the final issue is the issue of average weekly wage under KSA 44-511. And on this, the court has an unlimited standard of review because we're dealing just with the statutory interpretation. It is our position that the board erred because they continued to apply pre-2011 justifications in looking at average weekly wage. So pre-2011, there was a distinction between full-time workers, part-time workers, and you calculated different depending on how the worker was paid by the year, month, week, hour, output. The legislature did away with all of that in 2011, and there's now no distinction between full-time and part-time workers, no distinction between the methods of payment. Everyone's treated the same. What the board took issue with was the definition of calendar weeks. And after looking at other jurisdictions, they said a calendar week is Sunday through Saturday. And we're going to exclude any work week where you don't work Sunday through Saturday. And they based that on 3 different other board decisions, which had pre-2011 dates of accident. And they said that the only board decision to consider this after 2011 was an anomaly. Well, that's just not the case. When we look at the 3 decisions that the board cited, sure, they excluded partial weeks. The 3 decisions were Martin v. Royal Valley, Rubicalva v. Highland Dairy, and Reed v. Central Sand. But there's a reason that they excluded those partial weeks. It was either the first and the last week worked by the employee when they started and ended their employment were partial weeks. And so they didn't constitute a full calendar week employed, or they were dealing with the pre-2011 case law that says if you have time for sick leave or illness, those weeks are not included. Now, after 2011, that language comes out of the statute. So if you miss a partial week because of sickness or illness, that week's still included. That's because when the legislature amended the statute, they're presumed to know the law as it exists and to intend to change it. And so now when we get to the Stewart v. Access Control Solutions case, the only board decision I could find, which deals with average weekly wage calculations after 2011, the claimant worked 6 weeks and 1.5 days. He missed 2 days because he showed up late and his employer wouldn't let him work. And he missed 2.5 days because he was sick. So looking at that, after 2011, even though he missed 4.5 days of work spread out over a course of several weeks, I presume, the court still said you were employed and you actually worked during 7 weeks. And so we have to divide the gross wages that you earned by those 7 weeks. And that's consistent with the legislature's amendment to the statute in 2011. So what we are asking is for the court here to apply that exact same logic to the current case. The claimant was employed during the 26 weeks. He was employed for a total of 14. Now, 2 weeks he didn't work at all. We're going to take those out because he didn't actually work. And he didn't earn any wages.
You're
so
starting into your rebuttal time. So I just, okay, go ahead.
Thank you, Your Honor. I will reserve the remainder of my argument for rebuttal.
Okay. Mr. Rice, you have 3 minutes.
Your Honor, I don't think I'll even take 3 minutes. I'll just point out a few things. it's pretty simple how the ALJ and the board arrived at the 6.5. And it was because they were under the mistaken assumption that they were bound by the 6th edition and the 6th edition only. And the 6th edition rating by Dr. Marati was an 8. The 6th edition rating by Dr. Hufford was a 5. They took those two numbers and averaged them. So they didn't really deviate. And it happens all the time. They give equal weight to both doctors' opinions, but the only opinions they considered were those doctors' opinions under the 6th edition. So that's how you get to 6.5. It's not anything magical. It's what they thought they were bound by. Now, the other issue on this average weekly wage, if you take Mr. Wagner's argument, a person injured on a Monday would get less in an award than a person injured on a Friday, because sorry about your luck, you were injured Monday, you only got wages for Monday, but we include that whole week in the division. The person injured on a Friday got to earn wages that entire week, and that just can't be what was intended. So why would you treat people differently just based upon what day of the week they were injured? And I don't think that's the intent of the legislature. This court has an opportunity to finally let the ALJs in the state of Kansas know that they are allowed to deviate from the 6th edition so long as there's competent medical evidence. And I don't care what the evidence is. If it's competent medical evidence, it could just be anything. As I said, if it's first, fourth, second, third, some doctor made up his own guides, that's fine, so long as it can be determined to be competent medical evidence. Just because the statute says 4th doesn't mean we're bound by 4th or 6th. It's not a 4th or 6th argument. We'll agree it's 6th pursuant to Johnson, but we won't agree that it's 6th and 6th only. There's other evidence to consider, and the ALJs have been misapplying the law, misinterpreting the law, and under the mistaken assumption that they are bound only by the 6th. And
doesn't Zimmerow clear that up?
I think Zimmerow, as respectfully as I can judge, misses the mark in that I think Zimmerow, for some reason, presented the argument that it must be 4th. It's got to be 4th or 6th. What about 4th? That's not my argument. It's got to be, what about the other evidence? And I hesitate to say 4th. I wish it was just some other opinion out there. And if the ALJ, if it gets back to the ALJ and he considers all of that and says, guess what, my opinion remains the same, then fine. But you can clearly read each decision, and the decision I just got from an ALJ, that they are still struggling with what do we do post Johnson with this language of competent medical evidence, and they're scared. They're scared to do anything other than just follow that 6th edition. That's just not what the statute even says. So that's all I have.
Thank you. Mr. Wagner, 3 minutes.
Thank you, Your Honor. To just briefly respond to the 4th edition argument, I would implore the court to look at the appellant's brief, in which the sole argument that they presented was whether the ALG should have considered the 4th edition when they rendered an impairment rating. This explanation as to, no, I want them to consider everything, was never presented in the brief. It's just something that's been brought up on appeal during oral arguments. Additionally, I think if the court were to remand anything here, there shouldn't be any additional evidence considered. We have competent medical evidence in the record. It should only be remanded to fix the board's impairment rating, which was incorrectly issued based upon their own factual findings. Finally, when it comes to claimant attorney's argument about a claimant injured on a Monday versus a Friday, no one has ever argued that the week in which the claimant is injured is to be included. It's the week, 26 weeks immediately preceding the week of injury. And so where the board's logic fails is that, let's say a claimant worked 40 hours one week and he's on an as needed basis. So the next week he shows up, he works all 7 days, but he only works 1 hour a day. Now, under the board's logic, those should be treated equally. And I think that that's what has to happen. If you work, regardless of the number of hours that you work in a week, if you did work in that week and you were actually employed by the employer during a week, that gets included. Where we're going to start seeing issues is What about people who work shift work? You work 3 out of the 7 days in a week. Well, you didn't work a full calendar week. You only worked 3 out of 7 days, but maybe you work 36 hours. So is that included? Is that not? The simple answer is to just say, yes, if you actually work during the week and you are employed for a full calendar week, it's included. Thank you.
Okay, any questions of Mr. Wagner? Okay, thank you all very much. Very well argued, briefed case. We will take it under advisement and get an opinion out.